seated.
Thank you, Mr. Keel. You may proceed.
Ladies and gentlemen of the jury, this is my opportunity to present to you what is called a closing argument. The word argument is used because this is my opinion as to what I believe that the evidence demonstrated in this particular case. Mr. Longsworth presented to you this morning his closing argument. Mr. Longsworth will have an opportunity to speak to you again after I complete my closing argument. And the reason for that is quite simple. In the criminal case, the burden of proof is on the prosecution to prove each and every element of the charge beyond a reasonable doubt. So that's why he speaks to you first, because he initiates the cause of action, and he gets to speak to you again after I conclude, because he has the burden of proof. And I say that so that you will understand that the defendant has absolutely no burden of proof. Doesn't have to prove anything. Nothing whatsoever in this case. The prosecution must prove each and every element of this case beyond a reasonable doubt. And the reason why I keep talking to you about elements of the case, when you get your jury instruction, the court will set forth specific elements for each offense that Mr. Taylor is charged with in this case. And it will say what the elements are that make up the charge itself. And I'm saying not do they only have to prove the charge, for example, if it's murder or whatever it may be, they have to prove each element that the court enumerates to you that makes up that particular charge. So each element, first of all, must be proven beyond a reasonable doubt. So if it takes, for example, 3 elements, and it's an or, I must say, first prove 1, and number 2, and number 3. If proof beyond a reasonable doubt is only on the first 2 and it's not on the third and, then they have failed to prove the case beyond a reasonable doubt with respect to that particular element. And that's why I said we want to discuss the elements with you as how it's set forth. Now, in this particular case, you've heard something about reasonable doubt. You probably say to yourself, what constitutes reasonable doubt? It sounds like a nice legal term, but what does it really mean? Does it mean that the prosecution has to prove each and every element of the case beyond all doubt? No, it doesn't mean that. During the course of your jury voir dire, questions were proposed to you about reasonable doubt. In fact, some of you jurors were even asked specifically if you knew what reasonable doubt actually means. The reason why those questions were asked, because now it's particularly important that you understand the concept, because you're going to have to apply it in this particular case. Reasonable doubt is a doubt based upon reason, logic, and common sense. It's a doubt that would make an individual, as it proceeds through his or her regular day, to pause and stop and say, is that logical? Does that really add up? If it doesn't, then it's not reasonable doubt. Then it is not reasonable, rather, and it constitutes reasonable doubt. And that just kind of gives you an idea of what it means. Of course, when you make a decision in this case and you go to your deliberation, you can use logic and common sense. You have a right to say that although I've been told this by the prosecution or even by Mr. Keel, does it really make sense? Does it make sense to a moral certainty that I can say to myself when I go to bed at night that I am satisfied that I have done the right thing? Can I say beyond a reason that I'm certain beyond a reasonable doubt that the verdict that I render in this case, I can go to bed, I can sleep at night and say, you know what? I can face the world because I did the right thing. That's what it means to have reasonable doubt, proof by reason beyond a reasonable doubt. That's how you should feel. If you can't feel that, if If you can't be that kind of certain as to whether or not the elements of a case have been proven, then it's not beyond a reasonable doubt. In this particular case, as I told you earlier, the statements of the attorneys do not constitute evidence. The only evidence in this case is what you heard from the witness stand and the exhibits that are admitted so you can review them. What Mr. Longsworth stated this morning is not evidence. It was a nice, drawn-out scenario as to what he thinks happened, but it's not evidence. So don't be deceived into believing that you can build inference after inference based upon his statement and equal proof beyond a reasonable doubt. It just doesn't work that way. In this case, the charges are homicide, which is open murder. What constitutes open murder? Well, legally there are three subcategories under open murder. We're talking about murder 1 in the first degree. What is murder in the first degree? That requires premeditation. We'll talk to you about that a little bit more in detail, but premeditation. Then you have a specific intent crime, which is murder 2 in the second degree. Then you may have an intentional killing and sometimes an unintentional killing that equals manslaughter. These are your variations under open murder. That's what Mr. Taylor is charged with in this case, open murder. He's also charged with a count of criminal sexual conduct, assault with intent to commit sexual penetration. I think I may have mentioned this in opening statement. This used to be called attempted rape, for the lack of a better word, attempted rape. He's not charged with penetration. Penetration would be the succeeding in the action of inserting your penis into an orifice, for example, would constitute rape if it's by force. But in this case, he's not charged with the completion of an act. He's charged with the attempt to complete an act. And I'll talk to you about that a lot more in detail when we talk about some of the various scenarios that the prosecution wants you to believe. He's also charged with home invasion, and that's with the intent to commit a larceny therein. It's not sufficient just to enter a person's room or a home or whatever, but you have to, as you enter it, have the intent to commit a larceny at the time. And he's also charged with larceny in a building. A building, oftentimes people think of that as a store, and that would be theft would be larceny in a building. You go into a store and you steal, but the same thing applies if it's a dwelling place. In this particular situation, a dormitory room. So the question becomes, did Mr. Orange Taylor steal, as he's charged with, keys and panties? So when you get to that count, you say, did he steal keys and panties to constitute a larceny? So those are the four charges that Mr. Taylor is faced with.